received, 1, as required above, the landlord must provide a copy to the requesting tenant. Landlord may provide the copy of the lease in 1, paper format, 2, electronic format if requested by the tenant, and 3, email if the parties have communicated by email regarding the lease.
So is that for everyone that's over 18?
Anybody who is is a paying tenant in that apartment.
Right. And so do husband and wife, would they just be considered?
They would be considered 1. But you know, you and your best friend think that's going to be really great to move in together, because at the end of that lease, you're not best friends anymore.
Right. So you and Sally suit both.
That's right. You each of you want your copy of that lease. The pet agreement has been updated to allow people 2 more pets. That's it. 2 more pets. Just 2 more pets. Okay, information about the flood hazard areas. In regards to the flood zone, property that is located in a special flood hazard area lies in a V zone or an A zone. They are no longer disclosing what property it lies in. It's either in a flood zone or not in a flood zone.
Everything in the world is in a flood zone. I know, right now.
Well, and you know, I don't know if you feel the same way, but I tell all of my clients that here in Southeast Texas, it's not if, it's when. And even if you're not in a flood zone, get flood insurance. It's cheap. It's cheap, cheap, cheap. To, you know, if you have to replace drywall and carpeting and furniture and you don't have the flood insurance because you're not in a flood zone, you can't do it for only $500 or $600. And a flood policy is only $500 or $600. Now, if you're in a flood zone, that's a whole different story. But if you know somebody also that is in a flood zone, make sure that you do your buyers a favor and always get an updated elevation certificate. Elevations are constantly changing.
Can you explain elevation certificate?
Elevation certificate depicts the level of the land on what a policy is going to cost. So like from 0 to so many feet, from this feet to this feet. Obviously, the higher you're going up, the less the policy is going to be, all right? So when you do an elevation certificate, and a lot of insurance companies are requiring newer elevation certificates these days if you are in a flood zone. Recently, we had a client that a brand new elevation certificate literally saved the buyer over $600 a year in annual premium to that policy because the elevations had changed. So it has to do with the updating of drainage, all that kind of good stuff where water can be retained or not retained and flow off.
Is that provided by an inspector or is that available?
It's provided by the surveyor.
The surveyor.
Yes, sir.
I saw one already that had a certificate, elevation certificate, somebody sent me under documents.
Was it in a high-risk zone?
Yes.
Yeah, so you want to make sure, do your buyer a favor and just get the newest elevation certificate that's available. Okay. And then page 3. Elevation certificate is an important tool in determining flood insurance rates. It is used to provide elevation information that is necessary to ensure compliance with floodplain management laws. To determine the proper insurance premium rate, insurers rely on the elevation certificate to certify building elevations to an acceptable level above flood map levels. If available in your area, it is recommended that you obtain an elevation certificate for the property as soon as possible to accurately determine future flood insurance rates.
So the insurance company should be able to provide that for buyer and or seller.
Provide, the rates? Well, no. The elevation certificate is going to be from the surveyor.
So you just call a surveyor, survey company?
Yes.
You just say, I need a certificate.
I need an elevation certificate.
Yeah, but who cares? It's the insurance company that cares.
No, you care.
No, you
Or
care.
you care because you have insurance. Or
No,
getting
you care, it's your property.
Rates are determined by
But your rates are determined by the level of the elevation certificate.
Do you know how much it's for?
An elevation certificate, I believe it's about $250 or $300.
Now, can title order that, an elevation certificate along with this, a new survey?
If you ask us to order it, we will order it for you.
And then, of course, then the buyer can pay for it.
That's right.
If you order it in conjunction with a regular property survey, is there any savings?
No.
It's totally different.
So can that be paid at closing?
Yes. Yes, with final bills. Mhm.
So if a buyer, say a buyer requests one, or you say to a buyer, you know, we should get a certificate.
If the property's in a flood zone,
Well, based on what they said here earlier, they all are.
No. The verbiage was specifying zones A and D, which are the high-risk zones.
and they're no longer making that determination.
Wouldn't it be to the seller's best interest to get it done before it goes on the market? Because a lot of buyers don't want to buy a property that's in a flood zone.
Survey will make the determination as to whether or not a property is in a flood zone. So, and most buyers are getting new surveys.
It's better.
As a buyer's agent, you really want to get your clients new surveys, so it's the most accurate survey. A new survey will depict whether or not, and will disclose if the property is in a flood zone.
Will it describe which zone?
It's either yes or no. Yes.
It won't give you the numerical zone that it's in?
It'll be like X or.
So
Well, yeah, yeah.
It will tell you it's in an A zone.
Right, but it's not making the determination between A and V any longer.
Oh.
They're not telling you which one is more damaging.
It's just going to say it's in a high-risk zone.
That's right. Any other questions? No? Okay. Okay, this is the residential condominium contract. This is on the completed construction. And there's just a couple changes on this one. Page 6. Down at the bottom, under settlement and other expenses, paragraph A, item 3. Except as provided by 12A4 below, buyer shall pay any and all association fees or other charges resulting from the transfer of the property not to exceed, you must put in a dollar amount. Not all, not 0, you need to put in a dollar amount. That's right. And then, I'm sorry.
Excuse me, okay, this is just for the condominium association and transfer fee, but it does not include the transfer fee to, say, the township. Because there is a transfer fee.
Right.
Even on a condominium.
It's going to be on anything that's normally a buyer cost. They're just re-emphasizing it in this condominium contract.
Okay, so
But it could include the transfer.
It does.
That's right.
Or other charges.
if it's $100 and $100, $200 right there.
And then item number 4 is added. It says buyer shall pay any deposits or reserves required by closing by the association, which would be your township.
Or 6 months up front or out fee.
Whatever they require, right. And then, just like on the 1 to 4 where the broker's signature was added in 2012, it's now been added to the contract, the condominium contract.
Page 11, and just to clarify for our associates, your licensed supervisor is Raul Giorgi. That his name should be on that line on every contract.
His name, not his signature.
Correct.
Right.
His name.
His name
Phone number.
and office phone number, that's correct.
And not his direct line.
Sounds like experience. His phone is fine.
Okay, residential lease application. Property condition. Applicant is strongly encouraged to view the property prior to submitting any application. Landlord makes no express or limited warranties as to the property's condition. Applicant requests landlord consider the following repairs or treatments should applicant and landlord enter into a lease. And then down at the bottom, it says landlords. And now it's all, anywhere where it's landlord or property manager has been added to that line.
I just did an application for a tenant, and the little paragraph was not there on their own lease, because they had their own lease, and that was not there.
And they're not using the most current and updated lease.
They don't- Yeah, no, they have their own. They don't want it this, they wanted their own on the website.
Well, and you know, if they're not using a realtor, then they should be able to use any document they want to. You know?
But do we have to accept it as an agent, as a realtor?
You know, I can get the answer to that question, but that's a legal question, and I'm not an attorney.
Well, let me understand the question. Are you saying, does the landlord have to accept this? Is that your question?
No, dude, if we've got somebody here that has bringing a tenant,
Do we have to accept it?
Oh, and we're representing the landlord. Okay.
in the best interest of your tenant. Yeah, if you're representing, how is it in the best interest of your tenant if they're not using the most current documentation? Yeah, I can find out for you.
Well, and Frank, if a landlord is using their own written lease, at that point, we would have to, our tenant would have to have an attorney review that, correct?
Well, we would advise that,
Right.
but they would not be required to.
Not required to, but we would have to advise that.
That's always safe.
And then can we sign off, like if there's a signature line for an agent on a lease that was not written by TAR, we can't sign off on that.
Yeah, we don't sign them anyway. We're not a party to the lease.
But if they had a line on it for an agent, we couldn't
Mm-mm.
sign off on that.
Yeah, you're not a party to it. You should be signing.
That's right.
You should be signing as your commission arrangement. That's it.
Right. And that we would do that through a TAR form, some sort of TAR form.
Well, if it's advertised through the MLS, okay, the commission has already been publicly advertised. And typically, it's not going to show up. What I'm saying is that is the only time you should be signing anything as an agent on a lease.
I'm just thinking of, you know, if somebody's, like a for sale by owner kind of thing. If
Right.
somebody's leasing something on their own, because we've talked about this a couple times now, where the landlord may have their own specific lease written up,
Yes.
and it,
But really, that applies in any situation. Even if you're using
Right.
TAR or HAR forms, you're always on safe ground recommending that your clients seek a legal opinion.
That's right.
You're never going to get in trouble for that.
okay.
So the conclusion is, do not sign that form as an agent.
No, just for your commission.
That's that is my takeaway from the conversation, is that you are not a party to the contract.
Yeah, if you find a form like that that asks for the agent's signature, take it to Raul and get his opinion, but it would be
Okay.
highly unusual.
As far as the professional fee, that would be the car farm broker agreement.
Yes, the agreement between brokers.
Right.
Even though there's no broker.
Yeah, but if there's no broker on the other side, like there's no person, stuff like that.
Right, that's right, there's no broker on
We'll make sure you get paid something.
Well, again, if it's advertised in the MLS, that is a
That's right.
offer of compensation. That's enforceable.
Okay. Page 2, middle of the page. Will any pets, dogs, cats, birds, reptiles, fish, and any other pets be kept on the property? Yes or no? And then here, as per the pet agreement, 2 additional pets have been added. And then about halfway down under the yes and no questions, 3/4 of the way down, have had any credit problems, including any outstanding debt, e.g. student loans or medical bills, slow pays, or delinquencies. Okay, so the next document, authorization to release information. Page 3, additional comments has been added. And fees. Applicant submits a non-refundable fee of blank to entity or individual for processing and reviewing this application. Applicant will not submit an application deposit of to be applied to the security deposit upon execution of the lease or returned to applicant if a lease is not executed. Okay, so that comes back where we were talking about monies becoming part of the security deposit.
Is this presuming that they're writing a check for a security deposit and submitting that with the lease application?
I would assume so, yes. The next document is going to be your farm and ranch exclusive right to sell. Do we have farm and ranch in here? Do y'all do farm and ranch? Okay. So page 7 of 10. Did I miss one? Boy, I sure did. Well, and as we get further and further, some of it's very repetitious because it's the same changes coming in. But like on the other listing agreements, reimbursable fees, also adding other fees that may apply, or other fees and then also the fee simple has been added into paragraph 1 under protection period. Okay, page 7. Paragraph D, item 8, in response to inquiries from prospective buyers and other brokers, disclose whether the seller is considering more than one offer, provided that has been struck. More than one offer. Broker will not disclose the terms of any competing offer unless specifically instructed by the seller. And then on page 9, under 19, addenda and other documents. Addendum 4, the seller's disclosure of information of lead-based paint and lead-based paint hazards. Addendum 4 has been added. Paragraph 22. Item B is the fair housing paragraph again. Does anybody need me to go over it again? Okay. And then the signature lines have been updated as well. Okay, so page 6 of 11. A3, except as provided by, this is already in a document that we've talked about as far as the association fees, that the property tax not to exceed dollar amount, and the seller shall pay any excess. And then item number 4, buyer shall pay any deposits for reserves required at closing by the association. And then the update of the security line, of the signature lines on 11. The next document is your approximation of buyer's closing costs, which is, fees. I know a lot of the people that I've given this class to, their brokers or supervisor brokers have said, don't use this document. So you're more than welcome to if you wish, but remember that you're a realtor, you're not a lender, and you're not a title company. So, you know, right, be the source of the source and get the information directly from who's going to be quoting that information for you. All right? Inspection information. Instead of client, it says buyer or seller. Instruction concerning the use of TAR Form 2005 extension of residential lease. Updated information for January 1, 2014 has been added all the way in, and the deletion of January 1, 2010 has been deleted out. Simple stuff. Item 3 on the extension of residential lease, the named person and or contact information in paragraph 34F remains the same or is changed. So you're renewing a lease. Is it still going to be the same property manager, or is it now going to be the landlord as opposed to a property manager? And then on page 3, you'll see that most of it has been deleted. And then the next page, which is going to be 3, is under special statutory rights. Stalking has been added, just like in the other documents. And then under 3, sexual offenses. Certain sexual offenses or stalking if the tenant provides landlord with the documentation required by the tax law. Property code, excuse me.
It's taxes.
I must have, no. And then the residential lease inventory and condition form. On page 6, this form is not a repair request. Okay? Submit all requests for repairs separately in accordance with your lease, which we learned is in writing. Okay? And then this is the residential lease for a multifamily unit. It has all the same things in it that the other ones did, addressing window latches, door locks, peepholes, deadbolts, bang, 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 bang. And page 9, yard maintenance. A whole section has been added. Yard means all lawns, shrubbery, bushes, flowers, gardens, trees, rocks, or other landscaping and other foliage on or encroaching the property, or any easement appurtenant to the property does not include common areas maintained by an owners association. Maintain the yard means to perform such activities such as, but not limited to, mowing, fertilizing, and trimming the yard, controlling pests and weeds in the yard, and removing debris from the yard. Unless prohibited by the ordinance or other law, tenant, landlord will water the yard at reasonable and appropriate times, including but not limited to the following times. Landlord or landlord's expense will maintain the yard. Tenant will permit landlord contractors reasonable access to the yard and will remove any pet from the yard at appropriate times. Tenant at tenant's expense will maintain the yard. Yeah. Tenant will maintain and effect a scheduled yard maintenance contract with a contractor who regularly provides services. Bang.
Okay, question under that 3, I guess if it's by the part unleft by ordinance and or law, with the water deed restrictions we often have, in the tenant is not following those, then there's a fee, a fine associated, then that would be going back to tenant?
Yes. How many areas here in the Woodlands are watered by the association and you as the homeowner don't have the ability to water their yard? Are there a few? And I'm thinking that that's going to kind of come to that as well. But you know, if you know we're under a water system and you've got a landlord or you've got a tenant that you know you're only supposed to be watering like the even sides of the streets on the even sides of the day, right? And they're not abiding by that, then there's recourse. Failure to maintain, plus any administrative fees assessed by the landlord's agents and or other entity as provided by law. Payment of repair costs. Which we've already talked about as far as putting it in writing. Security devices, again, addressing latches on the windows, keyed doorknobs, keyed locks, peepholes, bang, bang, bang. It's getting very redundant at this point, isn't it? Stalking seems like to be a problem. That's right. Not dying, but stalking. You know who knows. So basically, I mean, all of these other changes are ones, there's 3 pages left, and that's all stuff that we've talked about. So thank you for sitting patiently through this very exciting class. Do y'all have any questions regarding this or any title questions at all?
I have a question. I work with a company, and in doing a lease, the company always requires a transfer addendum signed by the company stating that if the employee is transferred within 30 days, 60 days, or 90 days, the tenant can terminate the lease. Okay.
And that would.
Now, it says here in the lease, tenant is not entitled to early termination due to voluntary or involuntary job or school transfer.
Okay, but go down to the next paragraph. I believe it addresses it. Yeah, let me get there. It's page 13.